Well, next we're going to talk about identifying comparable agreements that you might use for finding external, especially external, comparable uncontrolled transactions or cuts for the transfer pricing projects on intangibles. So, uh, if you're looking for a cut, and especially external ones, and this is how most of our transfer pricing for intangibles is done, it's the primary method. uh, Essentially you're going to end up looking in third-party databases, and we're going to talk about where those databases are and some of the things that you can do to find them. But we wanted to talk before we got there about some of the issues that are likely to come up when you're trying to look at various issues and finding good comparable transactions. So one area to think about is when you see a related party contract where you're licensing not only, say, business systems and methods, process, know-how, etc., but also the trade name and trademarks and other things that business systems might include recipes. You might want to think about whether this is very much like a franchise and use a franchise agreements that are available between unrelated parties as a way to come up with the pricing for the related party transaction. Now, there are guides that are available, franchise guides, publications providing information about the various different franchise arrangements that are out there by industry segment. So this is all quite feasible. Now, note the guides don't always provide enough information to really validate the exact nature of the cut. So you may need to dig deeper into some of the other sources that we'll talk about. But the guide may help you find that data in other databases. Another point to consider is when you have a third party agreement that was entered into by the parties in order to settle up a litigation problem or a dispute relating to the ownership of the intangible. Now, this is often going to be in the contract that between them that specifies it in the introduction or in a preamble to it that says, in order to conclude this litigation that parties have agreed to, as follows. Now, let's think about this. This doesn't happen from a transaction where two unrelated parties willingly entered into the contract to license the intangible. It usually comes about where one party has infringed upon the intellectual property rights of the other. The one whose property has been infringed upon brings a suit. They go to court. The first party is saying, "No, I haven't done any such a thing. My invention is completely different than their invention," or whatever. And the court is going to end up, reaching a conclusion, or the two parties are going to negotiate it between themselves, depending upon whether they want to take it all the way to trial or not. But in those cases, clearly the party who has been accused of infringing on the intellectual property didn't intend to or didn't think that it needed to pay any royalty to the others. And while it may end up having to pay one because the court decides that is what happened, it's hardly a good price for saying this is exactly what two parties would agree to at arm's length. Now, some other points to consider. Um, the license agreement may refer to other agreements and other aspects of what's going on between parties. So, for example, a co-development agreement or a manufacturing agreement, etc., or other purchases. You may be that you license the intangible, but you're also buying goods and services from the same parties. And it may be that it's going to be difficult to separate out the payment for the intangibles if that's what you need to do in order to put a price on a royalty between your related parties. So if party A licensed the trademark rights and technical know-how to party B, and A and B both also entered into a product development and a service agreement under which A is providing services for an unrelated product, something completely different, the royalty that was negotiated between them may be a bit tainted by the payment for the services. An example is probably going to make this a little bit easier to understand. So let's assume that your cuts are contracts that include the purchase of both products and services and the licensing of intangibles. And here we've got 5 cuts to look at: A, B, C, D, and E. And we've taken the total fee that was paid in each of these examples and broken it down by whether it's paying for the products or the services or the intangibles. Now, the contracts might be quite specific, and therefore you can actually identify essentially what is the fee for the intangible according to the contract. And you can note that here in the gray portion of the bar is the portion that is for the intangible. But let's think about this a bit more. If we took those gray portions of the bars off and set them aside and said, this is how we're creating the arm's length range for our cut, for our comparable uncontrolled transactions, I'm going to bring up a marker here and say, do we really think that contract E here, that 0 is the right number for that royalty? Probably not, if it's a value. And the problem here is, and the way to think about this is that the buyers who are buying the products, services, and intangibles are really focused on the all-in price for everything all together. And if you notice in our example, all 5 contracts had the identical price of 9 in total. And if a seller, and in this case, let's say seller E, wanted to overcharge for products, but was willing to undercharge for the intangible, the buyer probably just really doesn't care. It doesn't matter to them. They know in total they're going to pay 9 in this example. So the existence of these collateral transactions may taint the reliability of the cut for the license of the intangible separately. And that's something you should always keep in mind when you look at these. On the other hand, it may be that you're buying a whole same collection of things, and in which case it might be a usable transaction. The key point always is asking yourself the question, is it comparable to my tested party? Now, other points for consideration, imagine that there's a distribution that was an agreement to be the distributor and a license agreement. And the compensation received for the licensing of the intangibles can't really be distinguished from the compensation received for the routine distribution operation. In that case, there may be some confusion as to how things are being done. If you can't get a good, clean, segmented number and know that it's not tainted by another transaction, you probably have to raise a question mark as to whether that is going to be a good comparable to work with. The agreement might be a co-development agreement with no licensing of intellectual property between the parties. There's often cases in which 2 parties agree to work together with each other to develop a new product jointly, and they each owned their own technologies, which they are bringing to the table, but they essentially agree not to charge each other for the use of that technology or that information while they jointly develop a third product. Also, the agreement may contain a royalty in a non-comparable term. So it may be, say, your transaction is priced in a percentage of sales, but the royalty might be stated as a payment per unit sold. That may or may not be able to be converted to the equivalent percentage of sales. And if that's the case, then it may not be usable. And sometimes you'll see some agreements where the actual payment for the royalty may be in stock options. So you give me the right to use your intangible, and in compensation, I give you some options on my stock. So if that intangible proves to be wonderfully valuable for me, it'll also end up being wonderfully valuable for you because the stock options will be in the money. So one of the other areas of royalties to think about is that you'll often see royalty schedules. And the schedules may be, the first case you're likely to see will be based upon sales volume, where, say in this little example, that the first $1 million of sales you pay 0 royalty on, the next 4 million you might pay a 1% royalty, and then sales above 5 million there's a 2% royalty. So this gives you a schedule by which you would calculate what the royalty would be. If this is the case, you want to ask yourself why. Why would 2 unrelated parties agree to this type of contract? And in all likelihood, it's going to have something to do with, is there some degree of uncertainty about the value of the intangible, which would be a reasonable thing to be wondering about. And so they've created a contract that's sort of, the seller says this is wonderfully valuable, you're going to make huge amounts of sales, I want a 2% royalty. And the buyer is saying, I'm not so sure, but if I hit 5 million or more in royalties, that 2% sounds pretty fair. But if I don't sell that much of this product, like less than $1 million, then I don't know that I really want to be paying royalties to you. It's a way for them to sort of share the risk of trying to develop the use of that intangible in some new market. So then what do you do in this case? Well, you want to ask yourself, is your related party really comparable in this contract? So is it comparable to this schedule? Does that make sense? Or is it much more comparable to, say, a specific point, like the high volume point, is that they've already are in this market where they've got very high volumes, you're going to sell this in large quantity. You might as well just go for the calculate the royalty as if they were selling way above the 5 million number, because that might be where they're at. And you do want to ask, does it make sense? So for example, if the related party had future anticipated sales of less than 1 million, would the royalty really be zero? Probably not. So you would look at, even though you have a contract with an unrelated party that says it's feasible to defend a zero royalty for this $1 million level, that's really probably been done between the related parties to protect the licensee, to say, if you don't sell at least $1 million worth, I don't expect you to have to pay me royalties. So this is one in which the whole thing is hinged on the sales level. Sometimes you see these done on timing. So you do want to pick the transaction that is pick the point in that comparable uncontrolled contract that's most comparable to your related party. And in this case, it may be based on sales. But in our next example, we're going to talk about royalty rates that vary year by year. So the royalty rate may be coming on and says in year 1 you'll pay 2%, in year 2 3%, in year 3 4%, and then years 4 and later you're going to go to a 5% royalty. So a very set schedule on this. Again, why do unrelated parties write such a contract? Well, it's pretty reasonable. It may be that the party is expecting a slow startup period, and it's not going to have normal profitability from this for a first few years. It may have to invest heavily in using this new technology or trademark or whatever it is that you're licensing, and so they're not going to come up to a full profitability on it for 3 years. In which case, the party licensing the technology or the intangible, whatever it is, may turn around and say, okay, we understand that you're going to have a slow startup. We will take a lower royalty in those early years while you come up the curve. You may need to be making some investments of your own to make this work. Now the question asked then is, well, if I think about my tested party, what stage of development are they in? Are they more like the year 1 customer, or are they more like the year 4+ customer? If they anticipate the same kind of 3-year ramp-up period, then it may be appropriate to use the schedule. Right here, you've got all the detail for how that would happen. On the other hand, if they're already in a very mature phase of their business, then you wouldn't want to compare them to this sort of startup phase, the ramp-up phase. You want to go straight to the 4th year and say, if they're in the mature phase and this contract says that in the mature phase you'll be paying 5%, then that then becomes the cut that you most likely want to use. So one of the other aspects of a royalty agreement that you may see is that there may be multiple royalties within one agreement. For example, different market channels might have different royalty rates. Say, for example, brick and mortar retail distribution might have a different royalty rate than, say, online sales distribution. Different product lines might have different royalty rates, or technologies might have different royalty rates or territories. Now, and that's fine. It's important to sort of understand that when you read through. When it comes down to coming up with your comparable set, each individual royalty rate for each product or sales channel or technology may be entered separately in the analysis. You can see that as a separate transaction sort of thing, so long as it's comparable. So if you decide that, say, they are licensing 2 or 3 or 4 technologies, but each of those technologies is roughly comparable or closely enough comparable that you would include them, then you could say, I have 3 observations from this contract for these 3 different technologies, identify them each separately with these separate royalty rates, and those are going to be 3 different cuts that I can use. So that summarizes essentially some of these aspects of what can come up with multiple royalty rates.